Hello everyone and welcome to today's lecture on psychiatry. So this is the second lecture and we have already discussed few things like definition of psychiatry, what is forensic psychiatry, then consciousness, memory, delirium, delusion, hallucination, illusion, phobia as well as impulse. So today we will discuss what lucid interval is. So in case of psychiatry, lucid interval is the period of sanity between two periods of insanity. As for example, if a person is insane and for a short period of time he becomes sane and again he will become insane. So that period of sanity between two periods of insanity is called as lucid interval. It is different from head injury. In head injury, the period of consciousness between two periods of unconsciousness is the lucid interval. So lucid interval is a period of normalcy with normal mental activities may find sometime in an insane person. In this, the symptom of insanity ceases altogether. The person behaves absolutely normal. He is able to judge and foresee the consequences of his acts. He may suddenly return to his insanity state. And this is the same period of insane, and he is responsible for his criminal act in this period of lucid interval. So what is the difference between insanity and head injuries lucid interval? If we talk about the history, in case of insanity, there will be history of mental illness, while in case of head injury, there will be history of head injury, of course. Then, in case of insanity, the lucid interval is preceded as well as followed by the period of insanity. But in case of head injury, it is preceded by phase of concussion and it is followed by phase of cerebral irritation and compression of the brain. And if we talk about the number of episodes of lucid interval, then in case of insanity, it is recurrent, while in case of head injury, it is usually and only once. Now, automatism, or also known as automatic behavior, it is acting without desire. Means in this, it is a conduct that is performed by a person whose consciousness is impaired to such an extent that he is not fully aware of his actions. There may be no consciousness at all of all the actions in question, or there may be awareness that fall below the level of subnormal consciousness. It is usually followed by amnesia. Now, coming to the what are the causes of this automatism? So, it can be due to concussion or cerebral disease. It can be due to epilepsy. It can be due to alcohol or drug usage. Usually, the drug is barbiturate or benzodiazepines. As for example, if we talk about the barbiturate automatism, then after taking a barbiturate, the person have drowsiness as well as amnesia. So he will forget that he has taken a pill. So he will again take the pill. Then again he will forget and then again he will take. So this repeated intake of barbiturate leads to death of that individual. So the manner of death in this case is accidental, not suicidal. And this is important for claim of insurance, because for insurance claims, then the death should be accidental, not suicidal. So even during sleep, that is known as somnambulism or sleepwalking. And the medico-legal importance is defense in a criminal charge. So it offers a defense in a criminal act or criminal charge. Now, who is a psychopath? Psychopath is a personality disorder where the person has recurrent episode of impulsive behavior, which is not acceptable to the social structure. So they are neither insane and they are not mentally defective. So characteristic, they always offend against society, first of all. Then secondly, they lack sympathy. Their behavior is not modified by experience and punishment. Moving on to the other characteristics, they are emotionally cool. They are incapable to understand the feelings and motivation of others. They may have temper outbursts. They may make verbal or physical attack without sufficient provocation. And if we talk about their medico-legal importance, then they are criminally responsible for their act. Now, there are two terms. One is psychosis and another one is neurosis. And the main difference between these two are three characteristic features. One is empathy, one is contact with reality, and insight. If all these three things, that is insight, contact with reality, and empathy, are present, then it is neurosis, and if these three things are absent, then it is psychosis. So psychosis is a state of mental illness which is characterized by disorder of behavior being withdrawn from reality. So insight is absent, empathy is lacking, and contact with the reality is lost. Now, if we talk about neurosis, it is a state of mental illness where the patient suffers from emotional or intellectual disorders, but his insights remain intact and the sense of reality is also present. So there will be no change in the personality, no disorder of thinking, and it is the reaction against conflicts and stress in mind. Now moving on, what is the difference between psychosis and neurosis? As I've already told, insight will be absent in psychosis but present in neurosis. Empathy will be there in neurosis but there will be lack of empathy in psychosis, and contact with reality is lost in psychosis but it is present in neurosis. Other than these three, psychosis, the severity is major, while in neurosis the severity is minor. And if we talk about lastly the genetic predisposition, so it is present in case of psychosis but absent in case of neurosis. Now the difference between true or real insanity and feigned insanity. Now we talk about the onset. So true insanity is gradual in onset while feigned insanity is sudden in onset. There is no motive in case of true insanity, while in case of feigned insanity there is presence of some crime or some motive is there. If we talk about the predisposing factors, in true insanity they are present, but in case of feigned insanity they are absent. The signs and symptoms that are clinical features are uniform in case of true insanity, while in feigned insanity they are present only when being observed. Facial expressions in case of true insanity are vacant looking, while in case of feigned insanity they are frequently changing. Insomnia is present in true insanity while it is absent in feigned insanity. If we talk about the exertion, so it will be there in feigned insanity but it will not be there in true insanity. Habits are dirty in case of true insanity but not so in feigned. Skin and lips are dry in true but normal in case of feigned. And if someone performs frequent examination, the person suffering from true insanity does not mind, but the person who is suffering from feigned insanity resists for fear of being detection or fear of being caught. Now coming to criminal as well as civil responsibility of an insane person. So what are the responsibilities if we talk about the civil cases as well as if we talk about the criminal cases? Now in civil cases, we will discuss all these things under the heading management of property, contract, marriage and divorce, adoption, competency of witness, validity of consent and testamentary capacity. In case of criminal, we will discuss it under the headings of McNaughton's rule, section 84 of IPC, that is Indian Penal Code, Durham's rule, Curran's rule, the Irresistible Impulse Act, the American Law Institute Act, and the lastly doctrine of diminished responsibility. Now first, civil responsibility, that is management of property and affairs of the insane. In this, if the court finds that the mentally ill person is not capable of taking care of himself as well as property, then the court will appoint a guardian. While if the court finds that the mentally ill person is capable of taking care of himself but not his property, then in that case the court will appoint a manager. So first of all, how it is done? So judicial inquisition is done, means someone has to apply in the court for the inquiry and to prove that the person is mentally ill or not. Now after that, the court will send the case for medical examination to a psychiatrist and wait for his report regarding the insanity and the extent of the mental illness, whether that person is capable of looking after his property or not. The court will decide two things. Either the court will provide a guardian or a manager, depending on whether he can take care of himself or not, or whether he can take care of himself but cannot take care of his property. So, on these two bases, the court will appoint a guardian as well as a manager. So, the court even may order to sell the property for the purpose to meet up the expenses, any debt or maintenance or payment of the cost for any judicial inquisition. The manager has no power to mortgage or sell such properties without the permission of the court. And if it is reported that the person has improved or cured, then another inquiry by the court is done. And if the court satisfy, then all the proceedings will be stopped. Now, moving on to contracts. If a person is mentally ill and he makes a contract, then that contract is invalid. But if he become mentally ill after signing the contract, then that contract will be valid. So, only a person of sound mind is competent to contract. So, when is a person said to have sound mind? If at the time when he makes the contract, he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. If other party can show it did not know the mental condition of the other party and the contract was fair, then contract may be held valid. And if the mental illness develops after contract is signed, then the contract is valid until and unless mental illness makes the other party unable to perform the service relevant to contract. Contract can be made during the lucid interval, means contracts made during the lucid interval will be valid. A sane man who is delirious from fever or who is so drunk that he cannot understand the terms of a contract or from a rational judgment as to its effect on his interest cannot contract while such delirium or drunkenness lasts. Either party is incapable of giving valid consent due to unsoundness of mind. There can be recurrent attacks of insanity or epilepsy. Divorce can be granted if either party prove unsoundness of mind. Talk about adoption. Any male who is of sound mind and is not a minor can adopt a child with the consent of his wife. Government services. A mentally ill person cannot enter a government service. If we talk about inheritance, then mentally ill person cannot be disqualified from inheritance to any property. The situation is less clear if a mentally ill person commits murder. Competency as a witness. An insane person is not competent to give evidence. But if he understands the obligation of an oath, he is competent to give the evidence. In lucid interval, he is competent to give the evidence. Consent. It is not valid in case of rape, causing death or grievous hurt or medical termination of pregnancy. Lastly, the testamentary capacity. It is the capacity to make a valid will, or it is the mental ability of a person to make a valid will. Will denote as a testamentary document. Now, what are the components of this? An understanding of the nature of the will, firstly. Secondly, knowledge of the property to be disposed. And thirdly, an inability to recognize those who may have justifiable claims on the property. Now, what are the salient features of testamentary deposition? First of all, it must be in writing. It should be signed by the testator in presence of two witnesses. Then an executor is appointed under the will by the testator to carry out its term after his death. Will can be modified by the testator any time before his death. The testator must be of sound mind, not being a minor. This will be invalid if it is taken under the influence of any other person. Firstly. Secondly, loss of judgment due to extreme of ages. Thirdly, in case of insanity. And fourthly, in excessive drinking state. And this will is valid when it is done in lucid interval. Secondly, if testator commits suicide immediately after making the will in the absence of evidence of mental disease. And the third one, delusion not affecting any way for disposal of property. So these all were the civil responsibilities of the insane. Now moving on to the criminal responsibilities of the insane. A mentally ill person is not punished for his crime as he devoid of free will, intelligence and the knowledge of the act. As for example, the murderer, he take the plea of mental illness for escape from the capital punishment. Now talking about what McNaughton's rule is. So first of all, it's history, how this McNaughton's rule came in force. So a 29-year-old Scottish had been suffering from delusion of persecution, means that the party in power were constantly following him, harassing him or planning conspiracy against him. He has that delusion of persecution, that others are going to harm him. So he decided to kill the Prime Minister in power, Sir Robert Peel. So he made a plan for the crime. He waited from the distance of the Prime Minister residence. Suddenly, he found that the Prime Minister came out with some other officers. Then he started firing on the Prime Minister. But mistakenly, he shot his private secretary, Henry Drummond. Court found him as insane, as not guilty by reason of insanity. He was sent to psychiatric hospital for treatment for life. So what is this McNaughton's rule? So McNaughton's rule states that an accused person is not legally responsible if it is clearly proved that at the time of committing the crime, he was suffering from such a defect of reason, from abnormality in mind, that he did not know the nature and quality of the act he was doing, or that what he was doing was wrong. So if we talk about the section 84 of Indian Penal Code is also derived from this McNaughton's rule only, and it states that nothing is an offense which is done by a person who at the time of doing it, by the reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. So this is section 84 of the Indian Penal Code. Coming to the Durham's rule of 1954. So all these rules, either McNaughton's rule, Durham's rule, Curran's rule, Alley test, all are same. Like the person is suffering from mental illness is not criminally responsible, but their statements are a little bit different. Now coming to Durham rule of 1954. An accused person is not criminally responsible if his unlawful act is the product of mental disease or mental defect. Coming to Curran's rule of 1961, an accused person is not criminally responsible if at the time of committing the act, he did not have the capacity to regulate his conduct to the requirements of the law as a result of the mental disease or the defect. Now, fourth one is the irresistible impulse test, that is New Hampshire doctrine. It states that an accused person is not criminally responsible even if he knows the nature and quality of his act and knows that he is wrong. If he is incapable of restraining himself from committing the act because of free agency of his will has been destroyed by mental disease. Now, the American Law Institute test of 1972. It states that a person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he lacks adequate capacity either to appreciate the criminality of his conduct or to adjust his conduct to the requirement of the law. Insanity and murder. If the mental disorder impairs the cognitive faculties of the accused, he is not held responsible for his acts. And if insanity affects only emotions and the will, but not the cognitive faculties, the person is held responsible for his act. Now, The doctrine of diminished responsibility. What this doctrine says that if an unlawful act is committed by a person who is suffering from some degree of mental illness, he should not be treated like a sane person who committed an unlawful act. So according to this theory, such mentally ill person have diminished responsibility, and the punishment for them for the commission of an unlawful act should be less as compared to normal person. So this is the doctrine of diminished responsibility. It is not followed in India. So it is a partial defense available to the accused. In India, we have section 84 of Indian Penal Code, which is a all or none law. That is, either the person is fully responsible for his criminal act or not responsible at all. So we are not following this law, that is diminished responsibility. And the countries offering this defense are England, France, Germany and Scotland. So the mental diseases most commonly qualifying for this defense, the disease or states like depression, paranoia, psychopathic personalities, obsession, as well as injury to the head. And those mental disease and states which do not qualify for this defense are bad temper, drug use, hatred, jealousy, low intelligence, poor judgment, as well as racial murders. Now lastly, we have responsibility of intoxicated person. So in civil cases as well as in criminal cases differently. Like in civil cases, if any intoxicated person involved in any civil responsibility, then the case will be considered according to the nature of the work and merit of the consequences. If we talk about criminal cases, then there are two sections. One is section 85 of Indian Penal Code and another one is section 86 of Indian Penal Code. What this section 85 of Indian Penal Code says that if a person is intoxicated involuntarily, means against his consent, or he doesn't know that, or someone else has given some intoxicating substance to that person. After that, he loses his control and did some criminal act. Then he is not responsible. That is section 85 IPC. Involuntary intoxication, he is not responsible. While in section 86 of IPC, if he voluntarily intoxicates some substance, it can be alcohol or anything or any drug, and then he loses his control and do some criminal act, then he is responsible for his action. So these are the two sections in criminal cases. One is 85, one is 86. 85 is involuntary intoxication and he will not be responsible. While 86 is voluntary intoxication, and in that he is responsible for his criminal act. Thank you.